Hi there, it's Amy Peters from Beneficial Trust and Will Company, and I just wanted to have a chat with you about signing your will and what can go wrong in the context of a recent case called Smith versus Ganning 2022. And the case revolved around a married couple, Mr. and Mrs Ganning, and it was actually their daughter, Laura, who contested the will made by the mother, Alison. The will had left the entire estate to husband Michael, so Alison had left her entire estate to her husband. Now, the will itself was not defective, but Laura, the daughter, alleged that the signing of the will was defective and brought proceedings to the court in 2021, saying that the will had been signed in the presence of one witness only. The husband, Michael, said that there had been two witnesses and that the requirements of the law had been met. And the decision mattered because if the will was found to be invalid, then the mother, Alison, would have been deemed to have died intestate. And as her estate was over the statutory legacy, which is currently 322,000, although the husband, Michael, would still inherit the bulk of the estate, so up to 322,000 and half of anything over that amount, the remainder would also benefit the daughter who'd contested the will and her brother immediately. So the daughter gave evidence that when the mother signed the will, only one witness had been present. The husband provided contradictory evidence, and so it was all up for grabs for the judge to make a ruling based on the statements provided by the witnesses themselves. Ultimately, it was found that the will had not been signed correctly because the witnesses had not signed in the presence of each other. So in one witness statement, she gave evidence that she saw the testator make a signature. It took place in the hospital during a visit to see the client and no one else was present. And she also confirmed there was a blank space for the other witness. The other witness said that at the time of making her signature in the kitchen of her house, the other witness signature was already in place. So the will was deemed to be deemed invalid. The estate was declared intestate, and therefore the husband did not inherit the total estate, which may not have been what his wife actually intended. So we can get as far as creating a will, making sure everything is in place and correct. But has it been signed correctly, and what are the hurdles that could arise? So I hope you found that interesting. We'll keep an eye out and there'll be some other case studies coming your way.